Good morning. Please be seated. Hey, we are here for oral argument on Mario Rodriguez-Ramirez versus State of Arizona. It's our number CR-25-0157. A couple things before we get started. First, we have a very full house today, which is always nice to see. It'd be nice to have it for every oral argument. We have students from the National Christian Forensics and Communications Associations. Welcome. I hope you enjoy the argument here today. And we also have a group of legislative interns here for both this oral argument and the next oral argument. So welcome to all of you as well. Council, you know that you have 20 minutes each. There's a podium timer for your use, and serve whatever time save whatever time you'd like for rebuttal, but you have to keep your time yourself. So please proceed.
Good morning, Your Honors. May it please the Court. My name is Quentin Gregory. I'm here today on behalf of the Maricopa County Attorney's Office, representing the state of Arizona. With me at council table this morning is Philip Garrow, my bureau chief at the County Attorney's Office. And I would also like to make the Court aware that the...
Excuse me just a second, yep. Council. The timer is not going, at least on the bench.
Oh. Go ahead. The referee decided.
30-second runoff.
Alrighty, sorry about
it's
that.
Okay.
Please proceed.
And I did want to let the court know that the victim is present in the courtroom today. I'm going to try my very best. I don't know how hopeful I am, but my very best to reserve 3 minutes of my time. Just last year in State versus Alvarez Soto, this court emphatically reaffirmed the longstanding principle that appellate courts may not independently review evidence. The court then cited to the Adair case for its reminder that appellate courts review trial court rulings on a motion to suppress in light of, or view the evidence in light of sustaining the verdict, favorable to sustaining the ruling, pardon me. And then in Waters versus O'Connor, a clergy penitent privilege case that I think every party and the amicus have discussed in their briefing, the Court of Appeals has at least implicitly reflected that standard of review for the privilege issue in this case, concluding that the trial court's fact-finding was amply supported by the record. Now, in this case, the Court of Appeals seems to have deviated from those principles. The trial court's findings were amply supported by the record. It made clear credibility determinations about the witnesses at the evidentiary hearing, and the court actually showed its work on page 5 and 6 of its briefing in particular, compiling two competing lists of facts that supported finding the privilege applied and facts that cut against the privilege. So it clearly engaged in the prescribed totality of the circumstances analysis that courts are supposed to engage in cases such as this. And then on review, the Court of Appeals seems to have discarded those findings and reviewed all of the evidence afresh. Now, one other issue that the Court of Appeals, or a principle that the Court of Appeals seems to have run afoul of, is the policy of restrictively interpreting privileges and following the principle that the courts and the people are entitled to every man's evidence. And so in light of that and in furtherance of that policy, the courts are supposed to take a narrow view of the privilege when they are reviewing whether or not it applies.
Counsel, could you go over the second prong? That seems to be the one that, from the, if I'm pronouncing it correctly, Archibald case.
That's how I say it.
The second prong, and that seems to really be the crux of the case here, is whether Padron was acting in his professional capacity and receiving a confession. Mm-hmm. So when we're looking at that, what is the standard? Is it from the point of view of the communicant in terms of what that person believes is going on? And is it subjective, entirely subjective, or do we look at the reasonableness, kind of an objective criteria of that person's belief?
Mm-hmm. I think the answer is both. So as this court discussed in the analogous case a few weeks ago, the MH case that this court released, you start with the subjective belief of the person seeking the privilege, or holding the privilege rather, and then you turn to analyzing whether or not that belief, if it existed, was objectively reasonable. And so the Waters versus O'Connor case seems to have already addressed that, granted not in terms of the second prong. The first prong was at issue there, whether or not the person was in fact a clergyman. And the Waters court rejected the defendant's testimony regarding her belief that the clergy was in fact clergy under the statute, and affirmed the trial court's finding that the belief was unreasonable.
Counsel, may I ask you a question with respect to that?
Of course.
So if we can, and I think both parties, including at the oral argument on the motion to suppress, address subjective, objective approach to this. My question for you is that subjective, that initial subjective review, how is it affected by, in this case, the trial court's credibility determinations?
I think the trial court's credibility determinations should weigh heavily or be weighted heavily in this analysis because to establish a subjective belief and even analyze the objective reasonableness of it, you start with Rodriguez-Ramirez's testimony. And so he testified that I believed I was approaching him, in the capacity as a pastor and for spiritual guidance. However, being the judge in the room, hearing and observing that testimony being given firsthand, the trial court was best suited to determine the veracity of that testimony. And she did reject it. And so what we are left with...
Let me ask you a follow-up on that. Did she reject it or did she just take it all into context? And this is my next question, taking all the context, because the answers are just one-word answers. Did you approach Pastor Padron with the intent of receiving spiritual guidance? And the answer is yes.
Correct.
Same thing with you expected confidentiality. Yes.
Correct.
My question is, did the trial court look at that in the context of Pastor Padron's testimony and weighing that credibility? And the broader question from that then is, what role does a pastor's testimony, and this is unusual, where we have both the communicant and the pastor testifying. What role would that pastor's testimony permissibly play in this analysis?
So the trial court in its order stated that Padron's testimony of the role that he was playing in, she found that to be irrelevant. And I agree in a limited sense that it is irrelevant to when you're starting out with the subjective prong of this test, because what Padron believed at the time and was thinking in his head is not relevant to what Rodriguez-Ramirez was thinking and what he believed. However, I do think that Padron's testimony about not only how he thought of the conversation, but that he was the one who wanted to meet to discuss this issue after the allegations had already surfaced, that does inform the totality of the circumstances, because you are looking at things like where the meeting took place, which we've conceded is not dispositive in this case, the types of things that are discussed, the tone of the conversation. There's a secondary source cited in the state's brief about when you are confronted, when the penitent is confronted by the clergy as an enemy, then it is not objectively reasonable for him to think that that is a privileged confidential conversation. And the example from that citation is actually being confronted by the father of the victim, which is obviously analogous to what happened here. So while Padron's testimony is not directly important to the subjective belief, it does inform the totality of the circumstances.
When you're looking at the point of view of the communicant here, Mr. Rodriguez-Ramirez, to think, well, am I speaking with Mr. Patron? I guess I should say pastor for both. I don't mean anything, right? Not. Sure. With Mr. Patron, am I going to him in a spiritual, for a spiritual reason or something, an official, whatever it is, professional capacity? So I understand that. Do you also look from the communicant's point of view whether it's actually a confession? Because that seems to be inherent in all of this as well. Is this a confession, which generally strikes me as an objective type of thing? I mean, the legislature uses that term confession. Do we simply look, okay, a confession is, and give it a definition like confessing a sin to get absolution or guidance?
Yep, of course. And I think that does get to the question of, what is a confession? And I think that to define that, we turn to the statute. There's a reason that the statute has created a three-pronged test, because I think it is trying to delineate and limit what sorts of communications are protected. And so there may be some room for the subjective testimony. That's the point of the evidentiary hearing. But also I do tend to think that it is a more objective analysis, because in the statute, it requires well, the professional character prong, which we're talking about, and then looking to the third prong, that all of this must occur within the course of discipline enjoined by the church. So you're going to have to, what constitutes a confession in one church or under one religious doctrine may not constitute a confession in another. And there's case law, I think it's in, I think it might be in the Archbeg case, I apologize, but where it talks about excuse me, that's the wrong case. I don't want to
Waters?
say the wrong case. Well, it's turning sort of to the confidentiality prong. And that's also, I think, implicit in the confession that if you are, these communications should be held forever as a secret in the breast of the receiver of those. And that's a Minnesota case that's cited in the.
Well, where is that written? I gave that some thought about confidentiality, and it's certainly, I suppose, implicit maybe in the word confession.
Mm-hmm.
But if you follow a particular church's methodology, like this church, you would go from a one-on-one conversation to a one-on-several conversation to potentially then having some type of public confession to the congregation as a whole. In that case, do we look at confidentiality?
We do, Your Honor. I think in every case across the nation, at least that has to deal with that issue, they have all acknowledged that confidentiality seems to be the cornerstone of every privilege.
Well, Counsel, let me redirect you just a moment there, because I think the Chief's question dealt with whether or not the communication is itself a confession. I think confidentiality is a component in considering whether or not you can assert the privilege, whether or not the privilege exists.
Sure.
But I have the same question, whether or not we should look at whether the communication itself is a confession. And I threw out Waters because I look at paragraph 17 and 18 of Waters, which discusses the basis for the privilege and talks about the need, this is in paragraph 17, the need of people to confide in without fear of reprisal, those entrusted with the pressing task of offering spiritual guidance so that the harmony of oneself and others can be realized. And then the next paragraph 18, people being encouraged to discuss their flawed acts with individuals who within the spiritual traditions and doctrines of their faith are qualified and capable of encouraging the communicants to abandon and perhaps make amends. Mm-hmm. Does that give us the guidance then? Because I know that Archbeg took its test from Scott v. Hammock, but Scott v. Hammock's discussion of confession may be overly broad with its reliance on other traditions. And so I guess my question, to reiterate the Chief's question, is can we look to Waters as guidance then in identifying whether the communication in the first instance is a confession?
I think we can look to Waters at least for some guiding principles on that. Now, there's the language that Your Honor quoted in there that does seem to take a stab at defining what might constitute a confession. I do maintain that it's going to vary as you move from practice church to church, religion to religion.
Oh, I agree with you.
Practices are.
It's going to have to be read broadly enough that we don't get ourselves entwined with First Amendment issues.
And I agree with
that. You can't say it's a sacramental confession like in the Episcopal tradition or the Catholic tradition. But what is it then?
It will have to be read broadly, but I also think that it cannot be read too broadly, because to cite the Waters case again, or to quote from there, they rejected allowing a confession to be privileged when it was made to a volunteer who was a music leader at the church, saying that interpreting the statute that way was not sufficiently linked to achieving the societal benefits justifying the existence of the privilege. So I think that same principle runs throughout the second and the third prong. And turning back to your question about disclosure to third parties when that may be within the practices of the church, that can be condoned and has been condoned. The question is whether such disclosure to third parties is made in furtherance of the purpose of the confession itself.
Would this, even in that case, would the statute protect it? Because the statute speaks in terms of a clergyman, I'm going to throw in, or woman, or priest. It doesn't say more, a congregation. So what about that? Would that, if part of confession is to a broader group that is not a clergyman or priest, does that then destroy any privilege that attached to the initial one-on-one confession?
Sure. I think reading textually, just as is the court's duty to do. It can be read that way, where your confession can only be made to a clergyman or priest, a clergywoman or whomever. It satisfies the first prong, and a third party's presence might vitiate that privilege. However, the concern is that reading the statute that way may run afoul of the First Amendment, as Justice Montgomery mentioned earlier, because there are religious practices like looking to the various LDS cases in Arizona, where it is established by the church's handbook or written policies. I can't recall exactly what it's called right now, but where it is not just a meeting with your bishop and then you're done. Then it can be a small committee meeting. It can be a meeting before the church. And that is the formal confessional process of that religious organization. And so,
well, counsel, how about this? We have footnote 2 in Waters. Everybody seems to be talking about Waters. And I agree with the Chief and Justice Montgomery. We might have to add another prong to the Archibald test and ask initially, is this a confession? And in footnote 2, they noted many courts have construed the term confession in light of the particular doctrine or discipline of the church to which the cleric belongs, and have held the confession requirement includes communications made in the course of religious counseling, guidance, and admonishment. That seems to be pretty broad, and it seems to, at least at first blush, seems to maybe take into concern the First Amendment concerns. I'm sure you've read footnote 2 of Waters. What are your thoughts on that?
So regarding adding that prong, I think that the prong itself is probably implicit in the language of the statute already. It's just the courts that crafted, that tried to parse out the statute didn't include that. I think in their amicus brief, AACJ did in fact throw that in as an extra prong. And so although we disagree on the outcome of this case, the state has no problem endorsing that reading of the statute.
Assume for purposes of argument that we agree that confidentiality is an element of a confession, and that we have added that as a separate prong to the Archibald test, and assume that we're willing to recognize that confidentiality may not be vitiated if there's disclosure to third parties, as long as it advances the purpose of the privilege. The trial court found that Mr. Rodriguez-Ramirez had no expectation of privacy or confidentiality here. Why? What are the reasons that would support the trial court's finding?
So those are, again, I think it's pages 5 and 6 of the trial court's order that list there. Primarily the discussion of the plan for Rodriguez-Ramirez to flee the jurisdiction and head to Las Vegas. The plan, which was not brought up in the first instance by Rodriguez-Ramirez, but co-pastor Padron, to speak with the victims' parents and try and dissuade them from reporting these crimes to the police for the purposes of, I think the quote is, "You have to look out for your freedom. I don't want you in jail." Things like that, avoiding the practical, non-religious or spiritual consequences of what had occurred.
And that's at cross purposes for the with respect to the purpose of the privilege, because the conversation, in your view, largely relates to mitigation of damages, avoiding legal consequence, trying to minimize the damage to the church itself. But these were all in the interest, the non-spiritual interest of Ramirez Rodriguez.
That's correct, Your Honor, and that reflects a couple of things. There's a case called Facciani. I'm going to take that pronunciation of the C because it is out of Louisiana, and it's 297 SO3D 823, where the court wrote, "The defendant clearly sought an audience with Pastor Lede after the victim had already spoken to the pastor for the sole purpose of defending or minimizing the accusations against him. This was made clear from the testimony and the defendant's actions." So I think that sufficiently reflects this case. Early on in the transcript, without going into too much detail, the court's aware of the allegations in this case. But the defendant said, no, they say it was this. It wasn't that. It was just these things. So clearly trying to minimize the damage. And then knowing later on and acquiescing to Pastor Padron's plan to go discuss with the family to, again, try and mitigate, as Your Honor said.
From your perspective, would you preclude the possibility of the initial, you talked about the initial portion of the conversation taking that into account as an important point of evaluating the totality of the circumstances. But would you preclude the possibility of a communication starting off as not being a confession, but it could morph into a confession at some point down the road? Because I do know there were discussions, spiritual aspects of the communications here, a prayer at the end, I believe.
Yes, Your Honor.
So would you preclude that possibility under the factors you've set forth here?
No, there are cases. The Gonzalez case out of Florida, I believe, or no, that's not the right. One of the cases the state cited in its brief where the privilege can be vitiated by. Now, granted, that was another co-pastor showing up, not in his capacity, and so the first portion of the conversation was privileged. The next part was not. But I would turn the court's attention to the principle that abuse of a privilege will make it vanish. And so it may be that hypothetically the privilege could apply at the first part of this conversation, but when things start to turn to practical mitigating, how can we get out of this? As Padron said, we're going to fight till the last consequence. It's Buell v. Superior Court, this court's case from 1964, quoting the U.S. Supreme Court in Clark, saying there's a privilege protecting communications between attorney and client, and it will take flight if the relation is abused. And the court later said, a privilege surviving until the relation is abused and then vanishing when abuse is shown to the satisfaction of the judge has been found to be a workable technique.
And Mr. Greg, did you want to ask a question?
I have a question I'd like to ask because I'm struggling with the limiting principle in terms of if we are going to recognize that in some religious traditions, confession is made to one individual, and then in others it may be made to the entire church, and discipline may be carried out by the whole body of the church. What if there's some element in a church that requires that the person go out and communicate with the neighbors and other people? And so where do we cut it off? Where do we say this goes beyond the protections of the privilege?
I think that particular hypothetical is a tricky question, and it is a very delicate crafting duty before this court because there are dire First Amendment concerns. It seems to be informed by the cornerstone of all of these privileges, which is the expectation of confidentiality. So if you are going to if your priest advises you to go to your neighbors to tell them your bad acts or bad thoughts or whatever the case may be, then it may be that while the privilege remains with the priest who advised you to do that, the privilege may not apply or extend to the neighbor, because once you have decided to follow that advice, you are speaking to a person that the privilege might not cover. In the context of spousal privilege, and I am trying to wrap up my time, in the context of attorney-client privilege, there's cases where a spouse is present, and that's found to be in furtherance of the purpose of the privilege, and so it doesn't vitiate it. But I do concede I don't have a clean answer for that.
You didn't mean to say that the privilege belongs to the priest, right? It arises
applies to the priest.
Okay.
Yes, Your Honor. No, it always belongs to
Right.
the confessor.
Yeah, I didn't want to introduce a whole new fundamental issue here.
So we would ask the court to affirm the trial court and vacate the Court of Appeals decision. Thank you.
Thank you, Mr. Gregory. And Mr. Blackwell.
May it please the court. My name is Jacquees Blackwell. I represent Pastor at the time, Pastor Rodriguez-Ramirez. I also was the defense counsel at the trial court level. This case strikes at the heart of the clergy penitent privilege and the fundamental right of individuals to seek spiritual guidance without fear of reprisal. ARS 13-4062, subsection 3, was enacted to protect the human need to disclose flawed acts to a spiritual counselor in total confidence so that harmony with oneself and others can be realized. The state asked this court to dissect the confession line by line, isolating secular statements from spiritual ones to defeat this privilege. But as this court recently reaffirmed in MH 2023-004502, the privilege inquiry must focus on communicant. Specifically, the test is whether the communicant subjectively believed they were approaching the professional to secure confidential services, and whether that subjective belief was objectively reasonable under the circumstances. When a fallen pastor intentionally seeks out his co-pastor in accordance with church discipline, confesses his spiritual unworthiness to preach, and bows his head to receive a formal pastoral prayer, his subjective belief that he engaged in a confidential spiritual confession is entirely objectively reasonable. The fact that
counsel, the trial court disagreed with that. The trial court made specific findings here, finding 19 and finding 21, that the defendant's testimony that he made admission to Pastor Padron in hope of attaining spiritual guidance is not credible. 21, given the totality of the circumstances, defendants claimed belief that he thought the admission made to Pastor Padron was confidential and purpose for spiritual guidance is not reasonable. And we started off the discussion about an abuse of discretion standard. And if there's reasonable evidence to support that trial court finding, we are to defer to that finding. How should we handle that issue?
Justice, I respectfully disagree with the trial court's finding that Rodriguez-Ramirez was incredible. I disagree because I was there first and foremost.
I imagine you disagree with him, and I respect that. But again, the record is what the record is, and we have a finding made by a trial court, and we have our very clear jurisprudence on what the abuse of discretion standard is and how we are to defer to that if there's reasonable evidence to support it. And we have a trial court that saw it, heard the testimony, and made a call. And as a former trial judge, I respect that.
Right.
So it doesn't seem, as I think with questions from my colleagues, it doesn't seem that the Court of Appeals gave that any deference at all. They didn't really even discuss much of the trial court's rulings on credibility. I'm finding and I'm reading that's a problem. So help me work through that.
Well, Justice, you have to look at the statute itself. And my argument at the trial court level is the same as it is here. We have a statute that determines how an individual, a penitent, goes and speaks to an individual pastor of their church who's working in their official capacity or official character, and they have a church discipline for taking confessions, and whether or not that privilege was waived by the penitent. In this particular case, Rodriguez-Ramirez followed that to the T. The trial court just had an issue with my client as he testified during the trial. She didn't have an issue with Pastor Padron. My issue here is if you look at the transcript, and in this case we have a transcript of a confession, which that's normally happen. Not that it's wrong, but normally courts looking at a confession, you're just looking at statements made by individuals who testified. In this particular case, justices, and just like the trial court, you have the transcript. So when you read the transcript, you don't take things out of context. There's a conversation about his spirituality, the fact that he was weighing heavy on his soul, what he had did, the fact that he had problems already for 3 years with his wife, that transferred to him doing something wrong with this little girl. He went to his co-pastor, the only pastor of the church that he could go to, who understood the discipline, to discuss his wrongdoing and to determine what they were going to do with the church. He was not looking at he's not looking at it from a perspective of fleeing, as the state would have you believe. He was looking at it from a perspective of taking care of his flock.
Yeah, I read the transcript, and after reading it, I came to the conclusion, at least, it seems like there's support for that it's a confession, and there's support for it's not a confession, either way. So like Justice Bean, I was rather left in the position of, well, it's the trial court that observed the credibility of the people who testified and weighed this. So I'm looking at this in terms of why isn't there insufficient evidence to support what the trial court found in terms of the defendant's testimony about the ones that we just cited, number 19, number 21. Why is there a lack of reasonable evidence to support that? Because if the trial court had gone the other way and said, yeah, this is a confession, it's privileged, I think I'd be saying, yeah, there's support for that for the reasons that you pointed out in your briefing. But there's also support the other way, it looks like, in terms of he wasn't the one to go originally. It was Pastor Padron that called him to come, and some of the other bits of the conversation. So could you persuade at least me of why is there a lack of evidence to support what the trial court found?
To make sure I understand what you're saying, lack of evidence to find what the trial court found. I think in my mind, I hear, why was the trial court wrong?
Right.
And based on the evidence that both the most objective evidence, Justice, is the transcript. And so we can disagree about why it would be reasonable for Rodriguez-Ramirez to go to his brother-in-law, who was actually an uncle of the victim in this case, and think, why would he go there? How could that be incompetence? But that's not the test. The test is whether or not it's reasonable for Rodriguez-Ramirez to go to an individual in his church that's a pastor and give a confession. And
Counsel,
so
isn't
yes,
the test
yes.
really whether there was evidence to support the ultimate judgment of the trial court, or it was completely arbitrary, capricious? It just does not make any sense. I mean, which of the two? Isn't abuse of discretion? There is nothing to support what the trial court did.
Yes.
Okay.
Yes, Justice.
And here, are there not facts that support what the trial court did?
No.
What do you make of the fact that Pastor Padron asked or encouraged the defendant in this case to seek the services of a prostitute? Why didn't he seek the services of a prostitute instead? That kind of conversation doesn't seem like something that would come from someone who is sanctioned by the church to give spiritual guidance. What do you make of that, or of the conversations about how to avoid being apprehended and how to avoid having the family reported and help him with the criminal consequences?
Justice, if you take a confession line by line, it's easy for any of us to scrutinize statements, particularly when you hear a pastor say something like, why didn't you choose to go with a prostitute? I think in my own practice, when individuals come to me in my office who are charged with sex crimes, I may ask something similar, but it doesn't take away from the attorney-client privilege.
Well, let me add one more fact that is sorely on my mind, which is from the beginning of the conversation, it begins not in the form of, Pastor Rodriguez, let's have this conversation. I understand there's something you want to unload or whatever it is, but it begins with, I really don't trust you, and I have not trusted you for a long time on account of things that have happened. The setup itself is not what traditionally would happen in the context of a confession.
Well, confessions, Justice, aren't always formulaic like as you would see on TV. A lot of people don't belong to the Catholic Church and are going to booths with the priest saying, "Forgive me, Father, for I've sinned." Myself, I'm not Catholic. I am Baptist, and I go to a Baptist church. And if I have an issue in our discipline, I can go to my pastor in an informal setting, be it at the church or in a park, and unload the wrongdoings that I have in my own heart, seeking spiritual guidance and absolution.
Counsel, if I can redirect the question just a bit. Because I hear what you're saying, and I don't disagree that when we have to look at the nature of the discipline enjoined by the church for what constitutes a confession for purposes of the privilege. And I understand discipline not to be punishment, but the discipline being, these are the strictures you have to observe in order for this to qualify as a confession. But with what Justice Cruz was mentioning, I think some of my colleagues have mentioned too, if we look at that transcript and we look at the findings by the trial court here, I struggle to come up with a different conclusion than the trial court, that the trial court's findings that the elements of the Archibald test were not met, other than the first one, to come up with a different conclusion with the standard we have to look at. I take your argument being that, and I appreciate it, that if you dissect the transcript line by line, you can certainly come up with one conclusion or another. But that's not the standard here for us to look at. We're not supposed to reweigh the evidence. The closest we can get to it would be to look at the facts and the findings of the trial court and then apply the privilege to it and find differently. But I'm having a hard time doing that, just as the Chief Justice is, to say that what the trial court ultimately said about that standard, about that test that's in the statutory privilege, was not met. So hopefully I've tried to distill that, at least of a different perspective, to give you an idea of where we're struggling.
Yes, Justice. I think if you look at the trial court's ruling itself, it's kind of disjointed when it comes to making statements about Pastor Padron and about Pastor Rodriguez-Ramirez. I say that because what I remember from her ruling was that she believed that Pastor Padron was credible. However, during the testimony, she even questioned Pastor Padron because he was trying to emote that he wasn't a pastor when they were talking in the park, but he was a pastor. He didn't give up his pastoral role just because he was in the park talking to his brother-in-law. And the court touched on that. However, she said that Mr. Rodriguez-Ramirez wasn't credible, not because he didn't, the situation didn't follow the statute. She just didn't believe that he was there for spiritual guidance. But the problem with that, Justice, is the entire time he was there, he was seeking spiritual guidance. He talked about leaving the church and how he had wanted to leave the church for months. He talked about how he wanted to bring up Pastor Homero from Mexico to basically do a changing of the guards in front of the congregation, so the congregation wouldn't think that there was something wrong. Why is my pastor leaving?
Pardon me for interrupting,
yes,
but
yes,
I want to, because now it seems that you're going through the transcript and the conversation to rebut the trial court's credibility determination.
Yes, Justice, because the
Well,
trial court.
how do I do that, though? I wasn't there. You were there,
right.
but I wasn't.
Because if the trial court, what we're asking the court to do is, if you're looking at it from an objectively reasonable perspective, the most objective data that we have in this particular case is the transcript, Justice Montgomery. And so,
But counsel, that your question or your request of us is basically for us to reweigh the evidence, and we just cannot do that.
no.
Again, stating the standard, we will find an abuse of discretion if there's any reasonable evidence in the record to sustain the finding. That's the paradigm in which we find ourselves in this case. And again, I think that you can read the bench here. We're having some trouble, dealing with that because we can't go line by line and reweigh it. We're stuck with what we have here. And in paragraph 21 of the trial court's finding, the trial judge said, given the totality of the circumstances. So it seems that she took into consideration everything here and still found your client lacking.
My client lacking, the problem with that is that here's a problem, Justice. We have three or four prongs to ARS 13-4062, subsection 3. Why I say 3 or 4, because the fourth prong could be, was there a confession? I think we all agree that there was a confession. The next step is, was it made to a person, to a pastor in their professional capacity? Pastor Padron, based on Judge Culbertson's own statement, the trial court statement, yes. So the issue is, how can she say yes to prong 2, but then say she didn't find prong 2? Because if Pastor Padron was actually working in his official capacity or his character as a pastor at that church, that's prong 2. And prong 3 is, was it done under the church's discipline? And did they have a discipline for it? They had a discipline for it, and it was done. Both pastors testified. Rodriguez-Ramirez testified that they followed the discipline, and Pastor Padron testified that he followed the discipline. And so the court, what I'm saying is, even though the trial court stated that she didn't find Rodriguez-Ramirez credible, You just look at the evidence speaks for itself. She could have had her own personal issue with the testimony that she heard from my client's mouth, but the objective evidence shows you that all prongs were met. And we're not asking you to reweigh the evidence. We're asking you to follow the Court of Appeals decision. The Court of Appeals looked at the situation that took place at the trial court level. It read the minute entry, just like all you justices did, and came to a conclusion that 13-4062 subsection 3 was followed. That's what the Court of Appeals did.
Counsel, let me ask you a question, though, about, again, with respect to the credibility determination, because it seemed when I was reading through the transcript that at one point, Mr. Rodriguez-Ramirez disagreed with Pastor Padron's understanding of the use of a tape recorder involving the young man, and that it was subsequently provided to the young man's mother. Pastor Padron testified that that was something that they would do occasionally, and that was something that Mr. Rodriguez-Ramirez flat out denied. So now you have a conflict between the two over what actually the discipline might be in terms of using a recording and then providing it to others. It would seem to me that that's a classic case then where the trial court has to make a determination of whose testimony is she going to go with. Am I reading that wrong?
Your Honor, you're not reading that wrong, but I don't recall the trial court coming up with that reason for distrusting Rodriguez-Ramirez.
No, and I don't see a specific reference to that, but what I'm suggesting is the record would support then why the trial court needed to make a credibility determination, because we have conflicting testimony about what the discipline of the church might be in terms of expectations of confidentiality, whether or not these confessions could be recorded, and what could be done with them. I guess my question is, isn't that something I need to consider that would support that credibility determination?
No, not at all, Your Honor, because the statute speaks for itself. There's no credibility determination embodied in the statute that we have.
But I guess maybe that begs, and I know your time's getting short. I guess, so the question I want to ask you about that is, but doesn't that bear on the subjective belief of the communicant? If the communicant's testimony has credibility issues, can't a court take that into consideration in finding whether or not the elements of the statutory privilege have been met?
And that's the problem that we have. The problem, Justice, the problem that we have is this. When it comes to us as this human being, you can believe me or disbelieve me. The issue is if you are a judge and you disbelieve me for whatever reason, it could be the suit, my tie, my glasses.
Well, I'm more concerned about evidentiary, not
what I'm trying to get to is this. At the trial court level, we don't know if the trial court judge stated that the most credible evidence is the transcript, then that's what we have. And that's what she said in her minute entry. And so her ruling. And so if we have that backdrop and you look at the transcript and you read it line by line and not take out the secular portions and give a bunch of credence to the prostitute statement, you have an individual who is with a co-pastor that he's known for 30 years, that the entire time told Rodriguez-Ramirez that he didn't want him to go to jail, didn't tell him he was recording the conversation, assured him that he would talk to the family. And you have Rodriguez-Ramirez not trying to leave the state because he could have just went to Mexico.
Counsel, let me interrupt because we are running short on time and I'd like to not extend it necessarily. But so the third prong of the test is whether the confession was made in the course of discipline and joined by the church. That requires the court to look at what is the discipline enjoined by the church, right?
Correct, Justice.
And
Correct.
so where does the trial court get that information?
The trial court didn't even go there if you look at her minute entry. And
well,
so
how does a trial court determine what is the framework for discipline within a church?
Well, in this particular case, Pastor Patron told her what the framework was. So in this particular case, the framework was a face-to-face meeting by themselves. It doesn't have to be at the church. In this case, it was a pandemic, so they met at the park. They talked about the wrongdoing. They talked about spiritual healing.
So then that framework comes from the testimony that's presented at the evidentiary hearing.
Yes.
And so
Yes,
in
sir.
this case, there was testimony from Pastor Padron and testimony from Rodriguez-Ramirez
Yes.
as
yes,
to
yes.
what that framework is. And some of it was not consistent with the other, correct?
One issue wasn't consistent would be Pastor Padron saying we always record and Rodriguez-Ramirez saying that's not true.
So what does the court do then to determine what the actual framework is?
The court goes right back to the statute.
Well,
And
the statute's not going to tell you what that church's framework is for discipline.
Well, I know I'm out of time, but Pastor Padron said what the discipline was. From his perspective, he followed the discipline. Pastor Rodriguez-Ramirez went there, he confessed.
Right, but
And
so when we have that conflict, and I'm asking Justice Montgomery's question in a different way. So when we have these two different statements about what the church framework is, then who resolves that?
Then the trial court resolves it.
Okay,
Yes.
thank you.
Thank you.
Okay, all right, I think you can give a last line if you want to ask us the last line.
I'm sorry, Justice.
You can go ahead and give us a last
Okay,
line.
I appreciate
You don't
it.
have to just,
Yep, you have a good closing. Thank you, thank you, thank
yeah,
you.
we kept you pretty active.
I appreciate that. Justice, we ask on behalf of Rodriguez-Ramirez that you follow the Court of Appeals decision. The Court of Appeals applies the statute 134062 subsection 2 correctly and affirms the Court of Appeals decision. Thank you.
Thank you. Right, I thank all counsel for their briefing on this and their argument today. We'll, sensitive subject, we'll give it a lot of consideration, and we'll take the matter under advisement and issue a ruling in due course. Meanwhile, we're going to recess to allow the next party to come forward.